Thank you very much. Good to be in Kigali. I am here on account of the All Africa Moot Court competition, known also now as the Christoph Heinz Moot Court competition, that is organized on an annual basis by the Center for Human Rights, University of Pretoria. That brings together participants from across the continent, new students who are learning law for purpose of testing their skills, their knowledge of human rights, particularly their knowledge and skills relating to the African human rights system. So I am here in my capacity as a member of the African Commission on Human and People's Rights to be part of the judges who preside over the final round of the competition of the students. I was first in Rwanda in the context of other student of the Center for Human Rights, again University of Pretoria. Then it was, I think, the first time that the university organized a field trip as part of the study of human rights on the African continent in order to have a first-hand experience of a country that had experienced extraordinary violations involving mass atrocities in the context of the genocide against the Tutsi in 1994, and to understand how Rwanda, after having experienced that extraordinary horror, has been responding to and dealing with the human rights issues arising from that experience. So I came in the context of that study tour and field visit. My encounter at that time was with visiting some of the memorial sites, engaging with victims, but also experiencing at that time the Gacaca Court system that was starting to be implemented by Rwanda in response to that tragic experience. So coming back 21 years later, again in the context of the work of the Center for Human Rights, but in another capacity now as somebody who is involved in the promotion and protection of human rights at a continental level through the African Commission on Human and People's Rights. For me, the one striking thing is, of course, the reconstruction of Rwanda after that experience and the extraordinary change that at least, you know, going around the city, you clearly see that this is a country that has come a long way in turning a corner, rising from the ashes of the genocide and trying to leave that experience behind and build a prosperous and economically advanced and developed country. So I think the experience of reconstruction and development actually is one that stands out in terms of what I mean. It's difficult to compare Rwanda of 2003 to, at least in terms of my experience in Kigali, to what is today. I mean, back then, you know, people were still, the experience of the genocide was still very fresh. The state of, you know, infrastructure was still very poor, and then now and then, I mean, it's just unrecognizable. The Kigali of 2003, I can't recognize it and compare it to the Kigali of today. It was a very moving experience to come back and encounter that history as exhibited in the genocide memorial. I have been engaged on matters relating to the genocide against the Tutsi in the context of the work of the African Commission on Human and People's Rights, including in the course of leading, for example, the study of the African Commission on Transitional Justice in Africa. Also on account of participating in the annual commemoration of the genocide during, April, May, June. During those encounters, including my visit in 2003, I have had, some understanding of what has happened, right? But coming back and again visiting the genocide memorial made me feel as if I am actually encountering this for the very first time. It was the scale of what happened, the brutality of how the atrocities and the massacre were perpetrated. Some of the individual events, including, individual incidents, like, for example, one incident that, is left a very strong impression on me was a 10-year kid in the section where those kids who were killed was also being displayed, called David, and he and his family, including his mom, were being sheltered in the UN mission compound. And he was of the belief at the time that the UN mission would protect them. And his last word, as written there, was basically that, Mom, the UN would protect us. But he actually ended up being killed. And the way he was killed as well. I mean, those specific individual experiences make it, drive home the gravity of what happened, but also what those individual stories mean, that we are talking about, the most innocent of human beings who are being actually subjected to that kind of brutality and death for a very simple reason of being a member of a particular group. That is, so the impression is basically that it is very moving, my experience here, and one of the things as you start the visit, the short video, one of the narrators, who himself was a victim, basically says that, I don't think that people understand what happened in Rwanda. And going through that experience made me realize why he said what he said. I think for those of us who are far away and haven't gone through that scale of and nature of the brutality, it doesn't really adequately get to us to understand the kind of experience that people have gone through. And even after the visit, you are still left with this question: I really don't understand this thing. How come that this kind of stuff happens at that scale and with that kind of brutality? And really, it is one of those tragedies on which one struggles to understand and really get one's head around. I would imagine that it would be a number of factors, right? One, and very important, has to do with leadership. So a recognition that, and a resolve that what happened shouldn't hold us back, that we actually can rise from what happened and emerge to become a society that would ensure the non-recurrence of what happened, that would also rebuild a resilient system. It is, about that. So the leadership question is very important. Together with the leadership question is that resolve, both at the leadership level but also at the wider societal level, not to be held back, to rise from the ashes of the genocide, rebuild, and through that rebuilding, pay your respect for the lives that were lost, and for survivors, it is also a process of healing, through this reconstruction process that happened. So I think it's these factors of leadership, resolve, and the commitment of the wider society to rise from that, to build a better future for themselves, to overcome the horrors of what happened to them and to their loved ones, and create a condition in which survivors and the new generation would be able to imagine to live a dignified life. One thing that we need to understand in this one, human and people's rights provide with standards whereby states would have obligation in order to observe and comply with expectations, legal expectations and obligations that they have subscribed to under the African Charter. And compliance with those standards through establishing institutions, relevant institutions for the promotion and protection of human rights, through adopting relevant legislations that give effect to those rights enshrined in the African Charter on Human and People's Rights, and also through having institutions and bodies that are independent and empowered to actually safeguard those human rights standards, are a prerequisite for creating the conditions for avoiding and preventing the occurrence of that kind of calamity. That kind of calamity can only happen in an environment where those rights and freedoms do not have a space for their protection and for their enjoyment by individuals. So it is when you have that kind of lack of protection of those standards that you create the conditions for those kinds of events. That is why, for example, the African Commission, in its effort in advancing and advocating for and in demanding compliance with the standards of the African Charter and related human rights standards, basically advances the creation of those conditions that actually would make sure that those kinds of extraordinary events do not happen. All right? So indeed, the work of the Commission, the mandate of the Commission of itself is an exercise in preventing genocide, an exercise in preventing the ideology that leads to the occurrence of genocide. The world failed to prevent the occurrence of the genocide, despite the signs that were present for the possibility of the occurrence of the genocide. Once the massacre started, the world didn't do enough in order to contain the scale of, the atrocities that were being perpetrated. The Organization of African Unity at the time started that conversation, among others, for example, in 1994 in the OAU summit in Tunisia, former president of South Africa, Nelson Mandela, clearly articulated as to the fact that we have everything in us as Africans to avoid the tragedy that is unfolding in front of our eyes in Africa. We should be able to take responsibility for what is happening in the context of before us, because it was happening, the summit was happening as the tragedy was also unfolding at the time. And that led to the establishment of the panel of eminent personalities on the genocide against the Tutsi by the Organization of African Unity, through that was proposed by the former Ethiopian Prime Minister Meles Zenawi, and also the good work of former Secretary General of the OAU, Salim Ahmed Salim, who really facilitated the work of that that panel, who clearly outlined the limitations and the deficiencies of the Organization of African Unity to effectively address those kinds of situations. All these served as a background during the debate for transition from the Organization of African Unity to the African Union. Indeed, if you look at the Constitutive Act of the African Union, among other things, it recognized under Article 4H of the Constitutive Act the right of the African Union to intervene in cases of genocide, war crimes, crimes against humanity. For the first time in an international legal treaty, something like this being established. And it is because of the lessons from that tragic experience, and in an effort to actually heed the lessons of that experience and create a continental system that really would facilitate the prevention of the occurrence of another similar kind of tragedy, that those, the Constitutive Act of the African Union established that kind of standard. Indeed, at the time when that the genocide against the Tutsi happened, and subsequent to that, the challenge encountered by Rwanda are manifold. On the one hand, you have the entire legal system that was completely destroyed. On the other hand, you have large number of people who were engaged at a mass scale in the perpetration of those atrocities, in killing their neighbors, in killing people that they know, in killing, of course, children, and in engaging in other acts, including using rape as a weapon for extermination of the target group. Now, there is expectation on the part of victims and survivors that justice will be served. There is also expectation for Rwanda to create conditions on how not only to deliver justice for victims and survivors, but also to rebuild state-society relationship and to mend totally broken fabric and torn apart fabric of the society. That is the context in which the resort to the Gacaca Court system came about. It is an attempt basically to use the local legal and conflict resolution resources and adapt them in order to meet these extraordinary demands that Rwanda was facing against the background of that catastrophe that it experienced. And from that perspective, if you look at it from that perspective, what were the options that Rwanda had at the time? One option would be the establishment of an international judicial mechanism that would deal with, a crime of an extraordinary nature, like genocide, war crimes, and crimes against humanity, which were perpetrated in the course of that catastrophe, right? Indeed, that was done, all right? But that international tribunal can only deal with a handful of cases. And if you leave it at that, then you would have a huge vacuum of impunity, a huge case of failing to deliver to the expectations of victims and survivors in terms of getting justice with respect to those heinous acts perpetrated by a large number of people. And that is not a tenable proposition. National courts were not functional. The legal profession was among the major victims of the genocide as well. So in this context, therefore, that response was basically a response that is meant to really arise to the occasion and use a local innovative solution for this extraordinary circumstance. So it actually tried to address the immediate challenge that a country coming out of that kind of extraordinary catastrophe was trying to deal with, both in terms of delivering justice, but also in terms of trying to rebuild the social fabric that was torn apart as a result of that incident. So in a way, the Gacaca court system as such is it also resonates with the experience of people, the vast majority of Rwandans, who have been using this for generations in trying to deliver justice, but also when the equilibrium of social relationships were broken as a result of the occurrence of a crime or a violence, it is through that system that they were restoring that equilibrium. And it has, that restorative approach that it provides, rather than just basically focusing on only the perpetrators. The advantage that it brought is that it focused not just on the perpetrators. Yes, the perpetrators needed to be held accountable, but also it gave victims the opportunity to be heard, to also get a hearing, to also receive responsibility from those who actually wronged them. So it is a very unique experiment from which a lot of lessons can be learned in responding to this situation. Now, as to the criticisms, I think sometimes when we do things in a very technical way, it's easy to arrive at that kind of sweeping generalization about that particular situation. I don't think that standards that are established for dealing with violations that occur in the ordinary course of events, those standards couldn't be applied to what is basically an extraordinary event. This is an extraordinary event that requires a completely different standard and approach a completely different response from the ordinary response to circumstances. So if you consider the extraordinary nature of what Rwanda was confronted with, and on the basis of that, you measure it against what the Gacaca court system was seeking to do. You ask yourself, from the perspective of victims, have it made their expectations? That is one very important consideration. From the perspective of even perpetrators, what it has done is it actually brought about and provided a restorative justice approach rather than the what may be considered to be a punishment approach to these kinds of crimes. And I think it's important to understand the circumstances that necessitated the resort to the Gacaca court system. We can't apply standards that are designed to apply for ordinary circumstances, for violations that happen in ordinary course of things and events in ordinary circumstances, in order to actually apply those same standards for this kind of situation. That is really an untenable proposition. In international law, international human rights law, one of the questions that you ask, if there is a deviation from a certain standard, is whether there is a legitimate purpose for that deviation. And in this instance, there is a compelling, legitimate purpose for not being able to comply with that. International Criminal Tribunal doesn't provide you with an answer to that because it can only deal with very few cases. The national court system was not existence, and you have actually the scale and number of perpetrators was also enormous. And it is these circumstances that actually require you to make that deviation from these standards that apply in ordinary circumstances. Was this a legitimate one? You have to look at it also in that particular circumstance. And definitely the answer would be yes for this as well. It is on the basis of this that we need to understand the Gacaca court system and its contribution. And indeed, it is one that needs to be commended rather than criticized. Two ways of looking at this. The first way of looking at this is that if you look at the Genocide Convention of the UN, its definition of genocide is basically an act that is perpetrated against a specific ethnic, religious, linguistic group. So it's not an act that happens against, a people of a country at such. So there is that specificity. All right, and this, what happened in Rwanda, happened in Rwanda. It was perpetrated by, people in power, supported by others in the society, against a specific category of people. And those people who were the target of these acts, were the Tutsi. So basically, from a purely international law perspective, if you are to recognize what happened in Rwanda as a genocide, the only way that you can recognize it is that by reference to a specific category of people in Rwanda. And those specific category of people in Rwanda have to be a specific that are identified in terms of ethnicity, in terms of language, or in terms of religion. That's the first one. The second one is that if you think about what happened in Rwanda, in terms of, some say it's not just the Tutsi who are affected by what happened in Rwanda, and that is true. The Hutu, moderate Hutu, were also affected by what happened in Rwanda. Now, the essential question from a legal perspective is, who were the target, the main target of the perpetration of what happened in Rwanda? And given that, at the time, it was, it has to be perpetrated also by, through a state-sponsored, it's a state-sponsored act. It is not something that happens simply by a group of individuals. All right. If you look at it from all of these criteria, okay, you can only have a proper designation of this in terms of this being a genocide against the Tutsi. That doesn't deny the fact that there were Hutus who were affected by it, but it actually follows the standard of international law as established in the Genocide Convention. That is why the UN recognized and used this proper designation. That is also why the African Union, through a decision of the Assembly of the African Union, applied this same designation. And you find, therefore, that from a legal and human rights perspective, it is this proper use that we need to, for a number of reasons. It's not just from a perspective of the Genocide Convention, it's also from a perspective of making first for people who have been victimized, who were the target of this extraordinary. We owe it to them that we recognize that they were the target of this extraordinary act of violence, right? And second, it is also a way of, in so recognizing what you are doing is basically you are also making sure that it doesn't recur. Okay, you don't create a vague, environment, okay, for denial, okay, which is, of itself a continuation of what was already occurred. So the African Commission on Human and People's Rights have various mechanisms that deal with these kinds of issues, and indeed hate speech is not something that can be considered as being protected under the African Charter on Human and People's Rights or in the human rights standards of the African human rights system. Second, the Commission, for example, has established I play a role of being a focal point on transitional justice and human rights in Africa. And among other things, we deal with issues relating to denial of genocide, which is actually not something that is acceptable, both in terms of the African human rights system, but also internationally. We already have internationally a well-recognized system whereby denial of the Holocaust is something that, for example, in the European system, that is considered to be a criminal act, right? So I think we have to look at it from that perspective as well. Through our work, both through a promotion work that we do, but also through the development of studies, guidelines, including, for example, guidelines relating to freedom of expression, that actually specify that incitement of violence and hatred against a particular group is not something that can be considered as, something that is protected by law, but something that states need to regulate and effectively address as part of ensuring protection to those who may be subjected to those kinds of activities. In terms of what we have discussed, for me, the one thing that I would say that it is imperative that one of the things that is striking is that struck me with actually this one. While the reconstruction that happened and the effort towards turning a page and rebuild Rwanda gives you hope, but at the same time, if events that are happening both in Africa and elsewhere in the world are anything to go by, it makes you wonder whether we as humans tend to forget quickly about events, extraordinary events like that, and also our being casual about these kinds of things and forget the lessons from events like this one, because not heeding the lessons of this one often sets us up to actually repeat what happened, not necessarily in Rwanda, but elsewhere. The idea of heeding the lessons from Rwanda is basically what is called never again. And the idea of it is basically to ensure that it not only shouldn't happen in Rwanda, but also it shouldn't happen elsewhere as well. I'm not sure that we are doing enough in terms of heeding the lessons of what happened in Rwanda. And that is why the memorial site is such a profound contribution, not just for keeping the memories of those who lost their lives, but also importantly in helping the world to try as much as possible to ensure that it heeds the lessons from Rwanda and does everything it could in order to prevent its occurrence elsewhere. I have to say that we are not doing enough, and I do hope that this kind of that Rwanda continues to help the world, but also through these memorial processes, that we do everything we could to avoid the recurrence of this anywhere else in Africa, including in places like, for example, Darfur, in the context of the current war that is unfolding in Sudan.